Ladies and gentlemen of the jury, welcome to A Dictionary of Finance and our special legal jargon episode part 2. In fact, it's an entirely more competitive situation than usual on A Dictionary of Finance today.
Yes, this is Snooze You Lose, part 2. You can listen to the first part on our podcast page if you go to the last podcast we did. And it's a legal jargon game show. And we have lawyers from the European Investment Bank pitting their wits against each other. And in the end, we may decide, who is the best.
You can refer to me as Your Honor.
Your Honor.
This, you are the gentleman of the jury. And we have the counsel here, including Kinga Soltész.
Kinga is counsel in the European Investment Bank's Czech Republic, Slovakia, and Eastern Neighbours Division. We also have Tom Nguyen.
Tom is a counsel in the UK and Ireland unit of the European Investment Bank's Legal Directorate. It's hard to say that.
Yes.
Because it's from a Latin root. We'll get into some Latin today.
Yes. A simpler name, Maria Cerrato, who's a senior counsel for the EIB's Spain and Portugal Legal Division.
And Matthias Brzezinski is in the Austria and Germany legal unit of the EIB. We've pretty much got all of Europe covered. Now we just have to get all of Europe's legal system covered on A Dictionary of Finance, Snooze You Lose. For the second episode of our legal jargon game show, Snooze You Lose, we're going to start with Matthias, and this is possibly my favorite legal phrase, yank the bank. Matthias, what does that mean?
Well, yank the bank is a concept which is usually used in more complex financings, loan agreements. It means that the borrower has the possibility to get rid of a bank, of a certain lender in a group of lenders, in a syndicate. Typically this applies if a lender, for example, cannot provide the required financing, or maybe more simply and more common, if there is an amendment to this finance contract and this whole group of lenders agrees except one of the lenders, the borrower has the possibility to exchange this lender, and typically the conditions are provided in the contract.
It sounds like it might be an American phrase. Wait, do you know where it comes from? Or is that just because it's a yank?
Well, you think it was something to do with bank bashing, wouldn't you, after the financial crisis?
Uh-huh. But it's actually a good thing. It's actually a good thing.
It's
in your contract. If you have that in your contract,
it's good for borrowers who were
yeah.
under pressure, I think, during the financial crisis. I think, if I remember correctly, the origin of this may have been America, but it was in a London transaction that I came across it, where a borrower was under severe pressure and they encountered a difficult bank. After the financial crisis, banks were a lot more strict and limited in what flexibility or how they can accommodate certain requests or needs of a borrower. And so it's kind of naughty in a way, because the way a borrower gets around, as Matthias was saying, of this problem, a problematic bank, a trouble bank, as it were, being difficult, is to generally pay them out if the loan is already made.
So the bank that gets yanked, they do get their money back?
In most cases, Matthias, I think that's
exactly.
the concept, isn't it? They get paid out in full early, so they have to leave.
There is no penalty or any prepayment indemnity or any indemnity in general which needs to be paid. But of course, the lender will get the money back and interest and any other amounts which may be due under the contract.
So why wouldn't the banks just all want to get yanked? They just get their money and go. They're done with it.
Well, there may be external reasons why they cannot accept this change to this contract. Yeah.
Okay. These are typical and structured financing, which are typically for a very long period of time, for 20, 30 years. And this is a very good position for a bank if there is a well-operating syndicate or community of banks, they can work together, they can decide on issues smoothly, then it's a constant flow of income for them. So it's also good for the banks to have a stable portfolio which is performing. But also for the borrowers, they have just think about it. They have to operate a project. And let's assume that you have a motorway financing where unexpected things happen all the time. So if you have a nasty bank who always asks a lot of questions, never reply on time, and then they just causing headaches to the guys managing the financing of this company doing the motorway, their interest is to have a community of lenders who are easy to cooperate with.
But of course, in this situation, as Kinga said, is a long-term thing, and it's not all about the money. Often, it's a severe blow to the relationship between that borrower and a bank. So in most cases, it's pretty much game over in the bank-client relationship. Because once you yank the bank, the borrower is telling the bank, we don't want to do business with you anymore.
There's no de-yanking or kind of...
No physical or, relationship, no physical impact, but in terms of relationship, there are bruised egos, shall we say.
Let's stick with one that sounds also like you might be either British or American. Maria, carve out.
Well, carve out is something we lawyers spend lots of time working on and negotiating with our clients. A carve out is actually an exception to a general obligation. So if I'm going to give you money and I want to be repaid, I may tell you, well, during the lifetime of the loan, I don't want you to sell your assets. I want to keep your properties the way they are today because I want you to be financially strong enough until you pay me back. However, you may say, well, actually, I promised my dad that I was going to sell him my old part. And I promised that a year ago. I have to honor that obligation. I cannot do that to him. So you'll come back to me, the lender will look into it, and I'll say, well, okay, that old car is not a lot of value that is in there, so I think I can live with it. So in the contract, in the loan agreement between us, we are going to set an obligation in which you will commit not to sell your assets until you have paid me back. But we're going to introduce a carve out. We're going to introduce an exception in which you can freely sell your old car to your dad and you don't have to ask me for my permission. So at least you can be in peace with your dad, and we will be both happy about it.
That's very clear and simple. I actually feel like I understood it.
You're becoming a lawyer. But one of the things about lawyers that we associate with them is what we should call, I suppose, sneaky tricks. This is one of the things why we love legal fiction and things like that, and we like to watch them on TV. So, Tom, a sneaky trick. To the best of my knowledge, after due inquiry.
Yes, this is one of those gems, folks, where, you toing and froing, arguing for hours and days and weeks, and people obviously saying that, it goes back to the point that Matthias and Maria were saying about reps and warranties and covenants. Obviously, when a borrower makes a rep, they say, I have this much assets, I run this business this way, I make X amount of money, I could repay you, a 5 million each year, etc., etc. But if those reps were to be inaccurate or wrong, then it usually gives a lender a right to terminate the loan and demand it all back. So it's very important that when a party like a borrower or a company makes a rep, they are fully aware of what's going on in their business, their group, their holdings, their subsidiaries. So it's very important when they make those reps, they don't do it lightly. They have to know precisely how many trucks, tractors they have in the field. And then they would typically sometimes say, well, my group, my empire of business is so large, I can't possibly know how many microwaves, photocopyings we have. And then the banks would typically say, okay, we understand. It's so vast and so complicated and so spread out. You may not know to the minuscule details what you own, what you have, and make a certain representation, but we want you to make sure that you make these representations based on the best of your knowledge. And sometimes, and often, I would say, the best of a certain borrower or company's knowledge is not enough. We want them to go as far as saying, to the best of our knowledge, after due inquiry. So we typically sneak in some extra words to say after due inquiry, because there's no point them sitting at their office and say, yeah, we've got 500 tractors. We want them to actually go out there, make an actual due diligence check, due inquiry as it were, count how many tractors they have, and then come back to us and tell us.
Because actually it would be so easy to say, I didn't know. I mean, and it's very hard to prove that you know when you're saying it's something that it's within you. Either if you know or you don't know, it only you're able to say. So, but when you're adding that extra obligation, that extra bit saying, to the best of your knowledge, after having made due inquiry, you are raising the standards. You're saying, actually, you have to demonstrate that you did that piece of investigation and that you actually checked what was going on.
So it's actually a counter to sneaky tricks. It's not really a sneaky trick itself.
I always see this when I edit, that it's lighter for the borrower, because if they just make a statement saying there is no insolvency claim made against our company, it says there is no insolvency claim against my company, and if it's not the case, then they are 100% liable. Mm-hmm. But there are certain cases where there is actually a claim, but they were not in the position to know about it because it was submitted to a court, and the court didn't inform them yet, and there is no publicly available database from where, even after due inquiry, they would be able to tell this. So I tend to accept this request if I think it's reasonable that they, and even if they are very diligent and they do all the inquiries, they might not know everything about the situation.
Okay, so maybe it was just me thinking that lawyers have sneaky tricks. But one thing that people do think about lawyers as well is that they can be great orators. They can speak quite poetically. Which brings me, Kinga, to this one, which is very poetic. Insolvency waterfall.
Well, I agree the waterfall part is quite poetic, but in banking law or corporate law general, this is not so much. I think it's one of the saddest situations what can happen in the life of a corporate when it goes into insolvency, which means that due to the fact that it is not able to pay its payment obligations, it will be sadly terminated without legal successor. And the waterfall in this situation means that in the process of the insolvency, the court-appointed liquidator will sell all the assets of this company and basically give it to the creditors, and the order in which the creditors get satisfaction from the insolvency pool, so you see it's all related to water, it's called insolvency waterfall. So first the so-called secured creditors will be satisfied. In your case, Maria will have the proceeds of your watch, and then the claims of the state, of course, will be satisfied, and then the rest. And the bottom of the waterfall is the shareholder category.
So does a waterfall, does that have steps, or how do you call it? Does a water fall down ladders, or? It's
called categories.
Categories, okay.
And
that's not so poetic anymore.
No, not really. I'm sorry.
But poetry is sad quite often, I think. So insolvency waterfall, I think, makes
melancholic.
a lot of sense. Yes,
melancholic.
it is.
Yeah.
Yes. But all lenders would like to be on top of the waterfall, that's for sure. Mm. The lower you are, the worse it gets.
Is there a legal term going over the insolvency waterfall in a barrel?
If you're a Canadian lawyer.
Yes, that's right. That's what they do. One more question, and then after that, Alar has his big surprise ending, which is the big tiebreaker. So I'm going back to you, Matthias. Boilerplate clause.
Boilerplate clauses are quite standard clauses, typically contained at the very end of the contract, such as choice of law or choice of forum, the court which shall be competent to hear the case, or rules on notices, meaning how the parties should communicate via email or in writing, or rules on assignment, confidentiality. Those are typically you concentrate on the main operative commercial terms of a contract, and typically you do not heavily negotiate those boilerplate clauses at the very end. However, it can happen that those clauses also become very important, confidentiality, or which is also called midnight clause, by the way, the dispute resolution clause, which is also typically negotiated at the very end, very late night. But once a dispute arises, then it's all of a sudden extremely important, and if it's not well drafted, then you have a problem.
But couldn't you just leave out the boilerplate clauses and just include acting reasonably?
Well, I'm afraid that would be too vague, and there are many concepts which indeed need to be covered by a contract, but which is typically standard language, which you don't really negotiate.
Midnight clause. I like that.
Clause,
That's my next novel, I think. So now we come ipso locator to Allah with his tie-breaking question.
Well, who can tell me what a drop-dead clause is?
I would say that this would be a provision if until a certain deadline certain things will not happen, then without any further discussion a certain other event will happen. In financial terms, I would say an event of default clause is like that. So if you don't pay, the bank will have immediately the right to accelerate the loan. So without further discussions, you will have to pay.
So it's tied to the
back.
concept drop dead date, because that is the date where you have to do something, and if you don't, God help you. Basically, everything, heaven's open and Armageddon.
I think
the drop dead date.
I think Kinga.
The drop dead date.
Yes, I think you got it. Yes, I think that's it. That's got to be it. But let's try one more.
Let's do it.
Okay. So, correct me if I'm wrong. I understand there's such a thing as a data room where you do due diligence.
Of course, oh yes.
What is that? Is that like is it a nice room? Is it carpet? What?
No, it's an ugly room because you go to the corporate to do the due diligence. It's a big room. Nobody uses it. So it's usually not natural light, but there are plenty of computers in there. Nothing's fancy happens there, and you just put all the lawyers and all the financial analysts into that room to work 4 hours and get all the data from that corporate into their computer, so that actually after that and after analyzing all that, they can produce their due diligence report. But it's not a fancy place, that for sure.
But I think it's a nice memory for all trainee lawyers, because you start your job going into data rooms and then physically be together with the papers. Though I have to say we are a younger generation, so data rooms nowadays more like only virtual, which means that you just sit in front of your own computer in your usual room and you just enter virtual space and you read through all the documents, typically thousands of pages. But good old times, when I started to work, my colleagues said that yes, when they started, they even had cases where they had to travel to Japan to check out this physical data room of the company. I'm afraid not anymore.
I spent 1 month in a data room.
The two typical
in Japan.
The two typical aspects of data room, I think, still exists is in a acquisition, M&A, corporate. A company buys or takes over another company, and they need to understand how much debt or how much problems a company has. So the target company that's being bought out will typically put in one room all the information, all the contracts it has with other. So if you're buying a cashew nut supplier, you need to know who his customers are, and he'll put in that room all the contracts he has with all the cashew nut buyers, grocery stores. And you send your junior lawyer, go in there and check if the contracts are valid and do they worth a certain amount, or do they have any penalties, liabilities that you inherit if you acquire that company? So you need to know what you're buying.
Would they provide any nuts though, just to keep you going?
They may ask you the quality of nuts if that was an issue, but or indeed, what hidden skeletons are there in the company.
But you cannot be too greedy, because then it would be bribery. If you eat too much nuts, you like it too much, it could qualify the report.
True. And the other context of data room, from experience, is where you've got litigation. You prepare the case to the court, and you need to understand the history of the dispute. And typically in the data room, as Kinga, the rest of us have mentioned, it's a due diligence exercise, information gathering. It can be fun.
So data rooms now exist only in M&A, mergers and acquisitions, litigation,
Yeah.
and Hollywood movies.
And
basically.
finance as well.
And finance a little
Yeah.
bit. Okay, you know why cashews are so expensive? It's because there's only one in each apple. There's an apple on a cashew tree, and there's one cashew nut in the middle of each one. So you need a lot of apples to have one bag. So that's why they're so expensive.
Fascinating.
So you did some due diligence on cashews.
Yeah, I don't know much about the
Sounds
law,
like you've
but I
had
know
some data
about
room, cashew data room experience yourself.
me and nuts.
I
know
learned
about nuts.
I learned a lot today about nuts and law. So
I'm
thank
happy
you,
to
everyone.
help. Happy to help. You're welcome. So this was a fantastic episode of the legal jargon part of the podcast that we do here, a dictionary of finance. Maybe we'll do another one. You can let us know if you enjoyed it. You can let us know what other legal terms you happen to have seen in your contracts that you would like our experts here to explain to us. Get in touch with us on Twitter. I'm at EIPMatt, M-A-T-T. I'm looking at Allah right now, who's about to spell his name out for you.
Yes, and I'm at Alar Tankler, at ALLARTANKLER.
I hope you're writing that down. If you're driving while you listen to this podcast, you can write to me at EIBMATT.
That is easier.
So we'll see you next week for another episode of A Dictionary of Finance.